Hello, I'm Jonathan van Bilsen. On behalf of the Scugog Chamber of Commerce, I'd like to welcome you today. Our guests are Stephanie Miner and Ian Johncox, and they're going to be discussing vaccination policies in the workplace. A very timely and informative session. This show will be aired on Rogers TV and the Scugog Chamber of Commerce website and their YouTube channel starting next week. Before we begin, I'd like to ask Michael Phillip, the chair of the Scugog Chamber of Commerce, to say a few words. Michael?
Thanks, John. My name is Michael Phillip, and I am the chair of the Scugog Chamber. I'd like to welcome you all here for our program today. This topic is very important for businesses to understand. And I'd like to thank our friends from MBJ for putting this together for all of you today. Please enjoy the presentation, and remember to follow the Scugog Chamber to stay up to date on things that are happening in and around Port Perry.
Thank you very much, Michael. What I'd like to do now is introduce Mr. Ian Johncox of Mason Bennett Johncox to begin the presentation. Ian, welcome.
Well, thank you, John. I have a few opening comments before I turn this over to Stephanie for her excellent presentation. And Stephanie's been kind enough to have done all the work for this presentation and to allow me to participate and take some of the credit. COVID-19 has been one of the biggest disruptions in the employment sector in modern times. And our patchwork of employment law, which is a collection of statutes made by the legislature and decades of common law made by the judges, they never contemplated a pandemic of this severity and this proportion. And at the start of the pandemic, we found ourselves with a very fluid situation as the various levels of government struggled to adapt to the rapidly evolving situation that we were facing. And we found ourselves giving advice to clients with the warning that the situation and our advice could change within days. In fact, it did change sometimes within just hours. And now at what we hope are the ending stages of this pandemic, we have found ourselves in a similarly fluid situation when it comes to vaccines and vaccine policies. And I can say that the law has never had to adapt so quickly as it has in the last 18 months. But that's what the law does. The law evolves. The Supreme Court of Canada once said that historically the common law evolved as a result of the courts making those incremental changes which were necessary in order to make the law comply with current societal values. A few years ago, the Ontario Court of Appeals said that innovative or legal arguments are made and the law develops, either gradually or in leaps and bounds. That's how the common law evolves. And most recently, in a case this year, in a case we were involved with, the court said one should not forget that the common law evolves as the changing times make it necessary to do so. Well, these days we're talking about leaps and bounds. We're hearing new developments. In just the last few days, the headlines included YouTube announcing that it is blocking and removing anti-vax misinformation. The TTC accused its union of encouraging its members not to disclose their vaccination status to management. So the TTC brought an application to the Labor Board claiming that the union's action amounted to an illegal strike. Now, very interestingly, the same day, the union then reversed course back down and is now encouraging its members to disclose their status. Why did they cave in so fast? I think they were destined to lose and lose badly. Another headline, the regulator for Alberta doctors was exploring ways to speed up the investigation process into physicians accused of spreading misinformation or treating patients with unproven COVID-19 remedies. The RCMP's union says it supports the right of RCMP officers to refuse to get vaccinated and will back up any member who refuses vaccination once the mandatory vaccine policy for the federal public service is in place. Good luck with that, we say. In Quebec, more than 17,000 healthcare workers will be suspended next month for refusing to be vaccinated against COVID-19. Nearly half of those members are frontline workers who are in direct contact with patients. The Ontario College of Physicians and Surgeons has barred a family doctor for providing exemptions to COVID-19 vaccines and face masks, alleging that he has deliberately spread misinformation about the ongoing pandemic. The college says he is incompetent and that he is engaged in disgraceful and dishonorable conduct. Those are very strong words. And just today, the Ontario government announced that anyone that works in a long-term care home will be required to be vaccinated and that rapid testing will not be sufficient. So the situation continues to change. And we're being strongly encouraged by local officers of health to develop vaccine policies. And that's what we're doing at our office for a lot of clients. So what are those policies supposed to look like? Well, our answer would have looked a lot different 24 months ago. It might have been different 6 weeks ago. Now, Stephanie's going to talk about this a little more, but just last week came out with their guidance saying that refusing a vaccine for reasons of personal preference is a choice, not a right. That there is no protection under the Human Rights Code for those people. So in our opinion, the overriding principle is to keep focused on the big picture. This is a global pandemic that has been disastrous for our economy, for our environment with all the PPE being used and disposed of, for our physical health, and for our mental health. Personal preferences that hinder the recovery are not going to be well received by the courts. So with that, I'm going to turn the matter over to Stephanie and let her explain vaccination policies.
Great, thank you very much, Ian. We have certainly received a lot of questions and calls in our office on this topic, so we're happy to be here today and discuss with all of you. We do have a PowerPoint presentation that we've prepared, which should be on your screen shortly. I'm going to start by displaying a brief agenda so you receive an idea of what we're going to talk about today. We will start with some introductory remarks and then really dive into where the legal obligations stem from. And those are the obligations of employers to their employees when it comes to COVID-19, vaccination, and other health and safety measures. We'll then jump in to talk about vaccination policies themselves, what should be included in the policies, perhaps some exemptions, non-compliance, privacy considerations, and so on. Towards the end of the presentation, we'll then go on to discuss vaccination policies for patrons, customers, clients, which will likely look a little bit different than the policies you have in place for your employees. Finally, at the end, as John mentioned, we will leave time for questions. We've collected a series of questions in advance and are happy to answer any questions that we do not get to during the bulk of our presentation. So let's dive in. First of all, it is worth echoing much of what Ian had said in that the regulations and the recommendations pertaining to COVID-19 are rapidly evolving. It really is an ever-changing landscape. And because COVID presents a new challenge for everyone, there are very few legal precedents right now for us to follow. The law is a little bit slow to catch up. And what that means is that relevant policies, procedures, and even some of the information you may hear today will likely require some updating as time goes on and as the law becomes clearer, which it will. I would also note that the majority of our presentation today will address vaccination policies pertaining to employees in non-unionized workplaces in Ontario. Okay, so the first question you'll see on your screen there asks, what are an employer's obligations for COVID-19 vaccinations in the workplace? First of all, any obligations in this regard are going to stem from health and safety legislation. In Ontario, that piece of legislation is titled the Occupational Health and Safety Act. I'm sure it's an act that many of you are familiar with. One of the things the Act says is that employers are required to take every precaution reasonable in the circumstances for the protection of their workers. Now, we can extend this obligation, of course, to the risk that COVID-19 presents. What that means is employers have a legal obligation to protect their workers from the risk of COVID-19 entering the workplace. There are additional provincial and regional requirements, and actually when the government allowed businesses to shift into stage 3 and open up, one of the requirements under that was that businesses do comply and operate in accordance with the recommendations of the medical officers of health, whether that be the chief medical officer or local officers. And what we're seeing more and more is that those officers of health are recommending vaccination policies in the workplace. Okay, so you as an employer now recognize your obligations. Let's contemplate policy implementation. The sort of million-dollar question, can an employer require mandatory vaccination? And if so, when? Generally, the answer to that question is yes. You are, of course, going to want to consider the context and the circumstances, the sector of your workplace, and maybe mandatory vaccination isn't for you, but that doesn't mean you shouldn't have a vaccination policy speaking to what the expectations are surrounding vaccination. Perhaps there's alternative for rapid testing, etc. Ultimately, an employer may implement a vaccine policy to comply with their obligations under the Occupational Health and Safety Act. Interestingly, the Human Rights Commission of Ontario just released guidelines, I believe on September 22nd, and they spoke directly to workplace vaccination requirements, taking the position that they are absolutely permissible. Of course, such policies are going to be subject to the necessary exemptions and accommodations under the code, which we will discuss later. But the key point is that even the Ontario Human Rights Commission are saying that vaccination requirements are absolutely reasonable in the workplace. From a management perspective, you may also want to consider the message that a vaccine policy sends to your employees. Or on the flip side of that, the message that not having a vaccine policy may send. And that could perhaps be the message that you as the employer are indifferent. It may lead your employees to further inquiry or confusion, perhaps taking the position that they don't feel safe or protected just because they don't know what your expectations are. So having a policy speaking to this issue is definitely going to provide clarity both for the employee and the employer. When we address the question of when is an appropriate time to implement a policy, I would definitely say now is definitely reasonable. We're seeing the policies come into play more and more, and there's certainly a lot of societal pressure. But again, you are going to want to take a look at the type of workplace you're operating in. If you are deemed a high-risk sector and there's perhaps quite a bit of interperson contact, that policy is going to be rather urgent and perhaps already in place. If many of your employees are still working from home and you're looking toward a date to start bringing those employees back into the workplace, a policy aligning with that time would definitely be reasonable as well. Okay, so let's move on. We understand our obligations. We've contemplated implementing our policy. It's now time to draft. What should a workplace vaccination policy include? You'll see I've noted there on the slide that there is no one-size-fits-all policy. There's not going to be one magic template that will work for every workplace because, again, it is context-specific. You're going to need to determine what the requirements are of your workplace to ensure you're meeting your obligations under the Occupational Health and Safety Act. What should be common among any policy, however, is the fact that it definitely should be in writing. It should be made clear, presented to your employees, and made accessible to them. So that may mean distributing the policy via email to your staff and then making sure it's accessible to them afterwards, perhaps even posting it around the workplace. Now, when we're looking at what exactly that policy is going to contain, I've put a list of some important factors that we should be considering while drafting. The first on that list there is context. Why is the policy important? Why is it being implemented now? I provide a little bit of background, and I think it's also a good opportunity for you as the employer to reiterate your commitment to the health and safety of all of your employees and your workplace. Next up, we have scope. Who does the policy apply to? Is it strictly your employees, or are you going to extend that policy to volunteers, to students? That should be laid out. definitions. I think it's easy to make the assumption that everyone may understand a term or a word the same way you do, which is not always the case. So you want to be very clear, eliminating any confusion. What is vaccine? How are we defining that term vaccine? In this case, it's likely a vaccine approved for use in Canada by the Canadian government for use against COVID-19. Another definition to perhaps consider would be proof of vaccination. What does that entail? What does fully vaccinated entail? Are you going to encompass in that definition perhaps further recommendations that may require booster shots? So you do want to put some thought into the terms you're going to be using throughout the policy. Requirements is next, and that's going to be the basis of your policy. And that's where, again, it's going to be context specific. Are you requiring all your employees to be vaccinated? Are you requiring only employees working in the office to be vaccinated? Are you providing alternatives, as mentioned, perhaps rapid testing? How often would that testing take place? Who would be covering the cost of that testing? So all those details you are going to want to lay out. Verification would be the evidence or the proof of vaccination that you're requiring, assuming you are doing so. Right now, that would be the official receipt that's issued by the Ontario Ministry of Health. That can be accessed through the government's website. And I would even recommend putting the link to the site where you can obtain that receipt right in your policy. So any employees who may not access it. Timeline. When is your policy going to come into force? When is it effective? If you are requiring mandatory vaccination and there are employees who are not yet vaccinated, you're going to want to allow a reasonable period of time for that employee to obtain their vaccination. You also may want to speak to how long the policy is going to be enforced. That may be a bit of an unknown at this time, but highlighting that the policy may be temporary and enforced for as long as necessary to comply with health and safety standards. That's likely a good idea. Privacy is also another big question. We get a lot of inquiries on privacy, and definitely something that you should be speaking to in your policy. We will address this in further detail later in the presentation, but ultimately you will want to state what information you're gathering from your employees, who has access to it, and for what purposes. Will it be disclosed? Those questions should be addressed. Of course, taking into consideration that there is a level of privacy that should be expected and maintained between you and your employees. Exemptions and accommodations. This is what the Ontario Human Rights Code speaks to. And again, we will be discussing this in a little bit more detail later, but you are going to want to outline what those substantiated exemptions would be, what the accommodation process would be for those who do have substantiated exemptions to your policy. Non-compliance and the consequences of that should also be outlined. It should be clear to employees that if they don't have a valid exemption and they've chosen not to comply with your policy, what is the outcome of that? Is it discipline? Is it termination? That should definitely be addressed. And then finally, we have updates. As Ian alluded to right at the beginning of the presentation here, this is an ever-evolving landscape, and more likely than not, your policy will require updating as more information becomes accessible. And that's worth noting in the policy itself, just allowing room to update, perhaps even stating who will be responsible for updating that policy. Okay, so let's talk a little bit about exemptions. Are there exemptions for mandatory vaccination? And if so, how should such exemptions be addressed? Now, the legal exemptions are going to stem from protected grounds under the Ontario Human Rights Code. And the big one in this context is, of course, your medical exemption, a medical exemption to receiving that COVID-19 vaccination. Now, I'm not a doctor, but I have been informed that the Ontario College of Physicians and Surgeons have received a directive cautioning doctors to ensure that they are only providing exemptions for very specific medical conditions, serious medical conditions that would prevent an employee or an individual from receiving a COVID-19 vaccine or present a very high risk. Ultimately, it's my understanding they aren't being given out too loosely. The second ground here that you'll note on the slide is the religious exemption. And this is an interesting one. I don't believe it's going to come into play very often, if at all, in this context. First of all, to reach that threshold of a religious exemption, it does need to be a belief that is more than just personal. We're looking at something that's more than just a personal belief. But what is interesting is that the Ontario Human Rights Commission has released some guidelines speaking to vaccine, which I alluded to earlier, and they do address religious exemptions specifically. And what they say is that even if a religious exemption perhaps is present, it's not going to outweigh the risk of COVID-19 or the risk that those who aren't vaccinated present. So that's going to mean that a religious exemption in this case, while maybe reasonable to contemplate, is not going to be very likely at all. Now, any employee who is seeking accommodation are required by law to self-identify to the employer and identify the specific ground that they believe vaccination would infringe, and then participate in their accommodation process, which may mean establishing the existence of that protected ground or exemption. When we talk about this in the context here, that's going to mean that the employee will likely be required to provide a medical note, a doctor's note, a nurse's note, in order to substantiate any medical exemption that they may be seeking. Now, that note is going to be looked at, of course, by the employer. They're going to want to ensure, of course, it's dated, it's on letterhead, it's signed by the medical professional. It's likely not going to say what the specific medical exemption is, but that one exists. It may outline some specific accommodations recommended by the doctor. And it may also include a time frame. Is this exemption indefinite or is it for a certain amount of time, a certain period of time? Once that medical exemption is substantiated, you have a duty as the employer to accommodate up to the point of undue hardship. And usually accommodation is a conversation with the employee and a joint effort to find what that accommodation is going to be. It's going to be different depending on the workplace, depending on the employee, depending on the circumstances. When we're looking at vaccination requirements, some of the accommodations an employer may want to consider would be working from home, if that's feasible for the role that the employee is in. Frequent rapid testing, we have mentioned a couple times, and if this is something that is going to be implemented, the Ontario Human Rights Commission has stated that it would be on the employer to cover the cost of such testing. That's something that as an employer you're going to want to consider because they can get quite pricey, those tests. I have cited at the bottom of the slide there a reference to the Ontario Human Rights Commission policy statement on COVID-19 vaccine mandates and proof of vaccine certificates. That is the document I've referred to a couple times now. If you are contemplating some exemptions and accommodation, it is a great resource for employers. It was just published a week or so ago, and it is available on the Ontario Human Rights Commission website. Okay, so let's move on to non-compliance. We're asking ourselves now, how do you address employees who may refuse vaccination or may take issue with a vaccination policy? as always, context matters here. You're going to want to try to maintain open dialogue with your employees throughout this process, and you likely are. I would hope you have done that over the past few months, the past year as well. So, implementing a policy speaking to vaccines shouldn't be too much of a surprise to employees, because there should already be, safety measures in place speaking to COVID-19, right? Masking, distancing, disinfection. So it shouldn't catch them too off guard. Now, if there are objections or employees who want to have a conversation, as an employer, you should absolutely be open to that. I think it's key that you're narrowing in and understanding exactly what it is that the employee is objecting to. Now, if their objection is not substantiated, so it's not I'll call it an official or a granted exemption under the Human Rights Code or under your policy, then the employee is absolutely required to comply with your policy, and it's worth stating that clearly to the employee. And you know what, that may be enough for the employee to then, understand the policy and therefore comply with the policy. If it's not, and we do have a bit of a difficult employee who is taking issue, you as the employer are going to want to be aware of possible repercussions, consequences for such non-compliance. That may be various forms of discipline. You may be willing to accommodate and do some jigging around with your policy. But the question I would say that we probably get most is about termination. Do you then have grounds as an employer to terminate that employee? When we're talking about termination, there are sort of two avenues. There's termination with cause and termination without cause. Now, if we're terminating without cause, that means that the employee is receiving the required notice and termination entitlements under law, and an employer can generally terminate without cause at any time for any reason. So that is definitely a possibility for employers. It's an option and would typically have little pushback. The other option, of course, is termination with cause. And that is when the employee is not entitled to notice and they are not entitled to their termination entitlements under law. Now, if an employee has not complied with the policy, is termination with cause an option? Perhaps. I believe that there are certain circumstances where a with cause termination would be warranted. Again, it's important to note that we don't have a lot of clarity in the law on this right now. We don't have a lot of precedence because the situation is so new. So I would caution employers that if you're considering a with cause termination or any termination generally, it's a very good idea to get legal advice on that, because again, it is going to be quite context specific, and you want to make sure you're going about the termination in a way that's going to mitigate your risk of any pushback. Doesn't mean you can't do it, but it does have to be done in the proper way under the proper circumstances. We also have I've heard of some options of potential leaves of absence or layoffs for employees who aren't complying, and those certainly could be possibilities. I'm not sure how common they would be in this context. Again, if that's something you're considering, I would definitely recommend getting some legal advice on that. Okay, let's move on to privacy considerations. Once again, this is a bit of a hot topic, and we're asking ourselves now, what are the relevant privacy considerations pertaining to employees and vaccine policies? In your policy itself, as I mentioned, you're going to want to consider what information you're requesting. In this case, it's more often than not going to be that proof of vaccination card or receipt. Right now we have not gone digital. I know that is supposed to be coming from the government later this month, but we are talking about that receipt that is being issued. Collecting that as an employer, I don't see as being a breach of your employee's privacy. It says their name, it says their date of birth, perhaps their address. Those are all factors and pieces of information that you would already have on file. Where the risk comes, of course, is if you start disclosing specific vaccination statuses of specific employees. And that's where you're going to run into problems. So you are going to want to assure employees that, it's being collected by management, it's being stored securely, and it's not going to be disclosed. Now, sometimes by the nature of how your policy unfolds, someone's vaccination status may become known. And I'm talking about a situation where perhaps you have an employee and they do have a substantiated exemption to vaccination or to your policy, and therefore you've accommodated them and they're working from home. The other employees naturally may conclude that that individual is not vaccinated because they're working from home. And that's okay, right? That's a reality. Where a line is crossed is if those other employees come to you and say, hey, is so-and-so working from home unvaccinated? You're not going to address that, of course. As the employer, your response would be, we do not discuss individual employee matters with others. So a distinction, again, between the general and the specifics. I also had the question before, can an employer advertise vaccination status of their employees? And I would say sure, as long as that's on a de-identified basis. Again, this is something I think we may be seeing more of as time goes on. Hey, 100% of our employees are vaccinated, and that's fine. Again, you're not going to be identifying specific individuals one way or the other. So I will reiterate then that all these details, how your information is being used, for what purposes, what specifically is being requested, that should all be addressed in the policy itself. And it doesn't have to get too detailed, but perhaps stating vaccination status information will only be collected, used, and disclosed as required for the reasonable purpose of, and you can list what that is. It's likely going to say the purpose of taking all reasonable precautions to maintain the health and safety of everyone in the workplace, the purpose of administering this policy, and as required by law. That would likely be sufficient, barring any exceptional circumstances for your sector. Okay, so let's move on and talk a little bit about policies for patrons. So up to this point, we've focused primarily on an employer-employee context. We've discussed what an employer's obligations are to their employees and what would be appropriate, reasonable, and warranted regarding vaccination policies for employees. Another avenue of that is, of course, vaccination policies for patrons, customers, clients. And those policies are likely going to look a little bit different than the policies we have in place for our employees. And that's just because the responsibilities and the requirements are likely going to be different. First off, I'll note that, of course, there are a sector of businesses that have already been subject to some government regulation, government rules that came into effect September 22nd, 2021. And I'm speaking about restaurants, bars, event spaces, sports and fitness facilities, concerts, these higher risk sectors. And they now are required to check the vaccination status of every customer, attendee entering the event or the facility. Unvaccinated patrons, of course, will not be granted entry. All these requirements are outlined in a document. It's titled Ontario Ministry of Health Proof of Vaccination Guidance. And that document I would recommend you have a look at if you do fall into one of those categories. You should already be having all of those requirements in play. We've had about a week or so to do so. But if you haven't looked at that guidance, you definitely should. It is available online on the government website. And I believe that many of the chambers also have made it accessible or even distributed it to their members. I'm not going to spend too long speaking about what it entails, but very quickly, I will note that it does require the business owner or an employee of the business owner to be verifying vaccination status against ID of an individual, so making sure those names match. The vaccination status does have to come in the form of the official receipt from the Ontario Ministry of Health. The business is not retaining this information. So unlike we're seeing with employees, this information is just being looked at, verified, and moving on. So you're not having a responsibility or a right to retain that information. And the guidelines also speak to medical exemptions, which of course are always present and a consideration to be aware of. Now, if you are not a business that falls into this higher risk sector, you have a little bit more leeway about what you want to do when it comes to potential vaccination policy for your customers. Again, as seems to be the theme of the presentation, this is going to be context specific. You're going to consider what is going to work best for your workplace. I would assume that workplaces that are not high risk sectors may not require mandatory vaccination for everyone entering, but they should certainly have some alternate measures in place. Distancing, limiting capacity, sanitizing on the way in, making sure you're doing your screening questions on the way in. Whatever's being done should be put in writing, and it would be a good idea to even have that posted so your customers, clients, depending on the nature of your business, of course, can see that on the way in. You have a policy in place, and you do, of course, again, want to contemplate the exemptions. In this case, the medical exemptions that would be applicable to whatever it is that you are requiring. Okay, so before we move on to questions, you can see there that we have posted our contact information. If you do have any questions that are not addressed today, we're happy to assist. And I would just caution or state that, well, vaccination is the hot topic right now, and it's certainly what we've spoken about today. It is one piece of the puzzle. And when we're looking at the legal obligations for employers to protect their employees and those health and safety standards that are in place, there's likely going to be more than just vaccination, right? We've dealt with masking requirements, with disinfection requirements, again, the sanitization, the distancing. So when you are developing a policy, if it is speaking just to vaccines, it's always good to remind employees and bring in sort of the full circle measures that you have put into place as an employer up to this point. Okay, so I'll finish there. I'll pass it off to John, and we will start our question period.
Thank you very much, Stephanie. That was wonderful information. We've had a few people who have asked questions about putting together an education policy, and I think the information that you shared today should give them enough tools to put an entire toolkit together for their organization. And I know that they can always reach out to your firm if they have more questions and so forth. It certainly is an interesting time. And I guess at the end of the day, the common goal is that we all want to stay safe, and everybody seems to be working towards that goal. So I don't want to lose sight of that, because sometimes we go off on tangents with things. And it brings up a lot more questions too. And this is a presentation we could probably have for 3 or 4 hours and still not cover it all. But thank you so much. I'm going to ask Ian Johncox to join us now for some of the questions that have come in from some of the folks that have been watching this. Ian, I know you must be dealing with a lot of different elements of this pandemic. The legal ramifications of the pandemic must just be really keeping you folks on your toes. The first question that came up, which was interesting, is how does an employee deal with an employer who does not believe there is a pandemic or parts thereof?
Yes, and vice versa. How does an employer deal with an employee who doesn't believe the pandemic is real. And honestly, if you don't believe the pandemic is real, you've got to have been living in a cave for the last 18 months. But for the employee who's dealing with it, and they've got an employer who is not taking this seriously, beyond trying to educate that person as to what's going on, which will probably be very difficult because the belief that it's not real is unreasonable, the employee is probably going to be making a call to the Ministry of Labor to file a complaint. And that's going to trigger a visit from an inspector, and the employer is going to be probably educated the first visit, and then if there's another visit, there's going to be enforcement. And really what the employer has to think of here is this: personal beliefs are irrelevant. The rules are the rules, and the pandemic has triggered a certain amount of rules in the workplace. And whether they believe the rules are appropriate or whether they believe the pandemic is real, it doesn't matter. The rules are there and they should be followed.
That's a very interesting, very valid point. I mean, I have concerns about the speed limit on certain roads. I think they should be higher. And if I drive faster, I know what's going to happen. It doesn't really matter what I think. It's the law is the law. And that's very true. Stephanie brought up a point which I was curious about. If an employee has a legitimate medical reason for not being vaccinated, and obviously through privacy, that stays as part of the conversation between the employer and that employee. What happens if I work in that environment, that person is working there as well, and I contract COVID from that, and I found out afterwards that the employer knew about this? Is there any sort of liability that would fall on them?
I think the issue there is, has the employer taken reasonable precautions, and has their conduct been reasonable in the circumstances? So if the person has a medical exemption, so that they can't get a vaccine, and they're working in the environment, what precautions did the employer take to protect the rest of the employees? And if those protections were reasonable, then I don't think the employer is going to have any responsibility.
So from an employee perspective, or from an employer perspective, if an employee does not believe in masking, social distancing, the stay-at-home orders and that, what can an employer do?
Well, in those contexts, you're really going to be first, hopefully, educating the employee about the importance of these measures and why they're being put in place. It's for their protection, it's for everyone else's protection. And then if you still don't get a positive response from your employee and you don't get compliance, you're going to trigger the discipline process, which ultimately would lead for termination for cause if they refuse to comply. So the employee has to really think hard and fast about whether they're going to continue that and how much they like their job.
Restaurants is a big element in this whole process because everybody loves to go to restaurants. The rules are ever changing, and now everybody has to show proof of vaccination, which is great, except staff. So this obviously, you had mentioned on the fact that Stephanie mentioned on the fact that you can possibly have a sign that says 100% vaccinated. That would not be in violation of any privacy, correct?
I don't think it would be. I think it's a good selling point for a business.
Well, it takes me back to the days, which you may recall, you being much younger than I, when smoking was banned in restaurant. When they first started doing that, I remember there were big signs in restaurants all over the place that say, we're a smoke-free facility. And then they started putting the signs on the tables and so forth. And people accepted it and people respected it. So it's I see it as that sort of a process. Would you agree with that?
I would agree with that. And I think that that's one of the things that the employer can use to try to encourage their staff to be vaccinated, is say, look, we'd like to be able to do this. It'll be better for our business if we can do this. We'll have more work.
How mandatory are these rules? So let's say that in a big city like Toronto, I understand, but in a small town, I go to the same restaurant quite often. I go in once, they do know me. I go in once, I show them my vaccination record and so forth. The next time I go in, they don't usually ask, or after 2 or 3 times, they don't ask and so forth, which is fine. And I appreciate that. But what happens if there's a patron sitting there who happens to notice that I just walk in, somebody says, "Hi, John, how are you?" I walk in, I sit down. Can they actually complain to the Board of Health and have something happen with that employer? Like, is that onus still on that employer?
That's an interesting fact situation. And I think the issue there is that, again, the restaurant doesn't have to retain that information, and they just have to ask and see it. And if the customer complains, oh, I didn't see the mask and see it, and the restaurant's response is going to be, well, John is a frequent customer. He's been here before. We've asked him if, we did ask him and saw it, when the rules came into place, we saw his vaccination proof at that time, and we don't, because we know that, we remember that, we haven't asked him again. That's going to be a pretty strong argument. On the other hand, now you're testing someone's memory and say, well, when was it that he first came in, and that sort of thing. So it's probably best practice to ask for it every single time, because then you can say, I always ask everyone every time, as opposed to saying, well, I don't ask people that I've asked before because I remember. And now you're putting your memory into issue in this case, where if you're being prosecuted for not following the guidelines, you're now saying, well, I have a mental log of all the people that I've asked and I haven't asked. That's sometimes difficult to prove.
Right. I can see it being an issue, because I know it has happened. It happens quite often. And the problem is if I walk in regularly and I don't have to show my proof because people know, but one day there's a new person there, a new employee, and they of course ask, and I don't happen to have the information with me, I could see it becoming a bit of an issue. But just to be very clear, restaurants do not have to disclose to patrons whether their employees are vaccinated or not, right? If I ask the owner, hey, is such and such waiter, waitress vaccinated, they do not have to disclose that, or they should not disclose that, correct?
They should not disclose that. That's correct.
All right, good. Okay, so this is an interesting question. Are employers required to accommodate to the point of undue hardship, so that if other options are available, such as negative COVID testing or making masking mandatory policies, is that an infringement on the employee's rights?
The short answer is no. The longer answer is that, first of all, there's no code protected ground. If you choose not to have a vaccine, that is a choice. I say choose, meaning you're not one of those people that's got a medical exemption. And choices have consequences. So, for example, John, if you had a swastika tattoo to your forehead, your career as an on-air personality would likely be over very soon. What we have seen, though, is that it's open to an employer to say, no, masking and rapid testing is not sufficient. That happened today when the Ontario government announced that for long-term care homes, masking and rapid testing is not going to be satisfactory. Everyone's going to have to be vaccinated.
And for the record, I wasn't thinking about putting a tattoo on my forehead.
And I wouldn't think you would either.
The sailboat on my chest is more than enough. How can an employer protect their liability from employees alleging that they're not doing enough to protect their health and safety without a vaccination policy?
Well, that's a great question. The employer has to take every reasonable effort to do what's necessary in the circumstances to assure the health of their employees. And if an employee is of the view that they're not doing enough, I would hope that the first step is a conversation between the employee and the employer to talk about those concerns and see if they can be addressed. If the employee is still not satisfied, then their next step is to call the Ministry of Labor. And an inspector will come along by and see whether or not those measures are good enough. And I think, assuming the measures aren't good enough, I would expect that the inspector would talk to the employer and say, look, these are the concerns we have. These are the concerns the employees have. They're valid concerns. You're going to have to tighten up your measures a bit. Or, conversely, the inspector may find that it's satisfactory and say to the employee, look, we're satisfied that what's here is good enough. And I would think that after that visit, either the employee is going to step up their efforts or the employee is going to be told that it's good enough. And if the employer did not step up their efforts and make things better, well, then they're going to face enforcement the next time.
I know that I believe they have just added 100 or so inspectors in Ontario, but do you have any idea what the turnaround time is from the time that a contact is made until somebody actually comes out? And if it's a matter of hours or days, it's not an issue. But if it's a couple of weeks, that's a pretty volatile period in between. Do you have any idea what that time span would be?
I don't know what the time span would be. I can only relate that in a few circumstances that I've had fact situations where inspectors have been called out, it's been pretty quick.
Okay.
We're not talking a couple of weeks.
Good to know. I know in the food industry, when a health inspector comes out to check a restaurant, it does happen quite often, very quickly from the time that they check the first time, and then they're given a grace period, which is a very short time. So I'm assuming it would be the same with this one, which is good to know because it is very important to everyone. Regarding the government's policy on requirements for certain sectors like restaurants, concert halls, are those sectors expected to expand?
I wouldn't expect them to expand. Those sectors, when you look at the sectors that have certain requirements, it's because those sectors present higher risks. Restaurants where people have their masks off to eat, gyms where people are exercising and sweating, and there's lots more bodily fluids being excreted in the environment. Concert halls and theaters where there are a lot of people in an environment, in an enclosed space for a longer period of time. All those present an elevated level of risk. And I would expect that the government has already had a good look at sectors and evaluated what they think is high risk and not high risk in coming up with that list.
Okay. A couple of people asked a question about forged documents. Now, obviously, it's against the law to forge a document, and I understand that. Is the onus on the owner of the business? So if, let's say, someone walks into a restaurant and the document is obviously forged, can they prevent the people from entering, first of all? And secondly, if they don't, what can they do?
Well, I think they can. I think any owner of business can prevent someone from entering the business. I would liken it to a bouncer at a nightclub. When they're carding people, if they think an identification is false, they're going to exclude admission to that person. And I think it's the same kind of thing. You're going to say, I don't believe this is valid. This is a valid document, and we're going to exclude admission. I don't see any significant consequences on the facility owner if they're doing that in good faith.
Okay. And consequently, I guess it's the same tone that if they feel that a client is not adhering to the rules, they don't have to deal with that client based on their understanding of the client's COVID or vaccination policy, correct?
Yes, and it's a judgment call. You've got to do that. You've got to try to do the right thing, keeping in mind that the default is keeping the safety of your patrons and your employees in mind.
And I guess it works two ways. If I'm a person looking to employ a service, if someone comes to my house for whatever to fix something and they refuse to disclose that they've been vaccinated, I don't have to let them in, correct?
I would agree. I mean, I think you would probably want to have that conversation before you invite them to your house in the first place, and certainly before you enter into any contract for service with these folks. If that's going to be one of the terms of your dealings with them, is that anyone that walks in my house is going to be vaccinated, that should be addressed in the initial conversation.
And I guess that would apply to businesses as well, probably more so, because if a business is going to deal with a supplier, they should preemptively have that conversation with the business before they actually engage the services, correct? Yeah. Okay. So if we have permitted employees to work from home for the past year and a half, 18, whatever it's been, are we creating a scenario whereby an employee can claim a constructive dismissal if or when the vaccination policy includes a full return to the work component?
No, I don't think they can. We got to keep in mind, what's the big picture here? People were allowed to work from home because the pandemic caused such massive disruption in the labor environment. So we created a measure to allow the businesses to continue operating. We made arrangements for people to be able to work at home. I don't think that a court's ever going to say, you've altered the person's contract of employment and now they have a right to insist to work from home. I don't agree with that at all. I think as soon as you've got the premises safe to get people back to work, you can get them back to work.
the question here, and I'll ask it again, I think it was more or less answered, but if you have clients asking for proof of vaccination, do you have to get permission from staff? Do owners have to get permission from staff before they can give that proof of information? Or should they just not even go there?
I wouldn't even give them the proof of vaccination. I would say to the client, look, our staff are vaccinated. And if the client says, I only want to deal with people who are vaccinated, well, then that's what you do. But I don't think you have to give a client, show them the proof that your staff are vaccinated. That's going to be violating the privacy interests of your staff. The client's going to have to take your word for it.
Okay. It is interesting, and I've had a couple of people mention, why is it that restaurants, for example, the staff does not have to be vaccinated?
In my view, and this is strictly a personal view and not a legal view, in my view, it would be a lot easier if the government said, look, everyone's got to get vaccinated. But they don't seem to be willing to do that. And so they're forcing everyone to make that decision and be the bad guy and create this patchwork of regulatory levels. It would be a lot easier if it was all coming from the top. So they haven't required restaurant staff to be vaccinated. But an individual restaurant could have a policy of their own saying, hey, all our staff have to be vaccinated.
So they are entitled to do that then. They don't have to disregard that. If they want to do that, they can.
They certainly can.
Okay. We've got about a minute and a half left. I've got one last question. It's quite lengthy. I'm going to read it here, and hopefully you can answer it in a minute and 15 seconds. The infectious disease emergency leave provisions of the Employment Standard Act appear to allow an employer to lay off an employee, but I've heard that some employees are claiming that this is a constructive dismissal. What's going on here is what they said.
Well, normally, and until recently, it had always been the case that you couldn't just lay someone off unless you had a right in your employment contract to do that. And that right could be expressed in terms in writing, or it could be implied by practice. So, for example, in the construction industry. When COVID hit, the government forced a lot of people to close their businesses or curtail their operation and cut them back, and a lot of people got laid off. And so they created some new rules to deal with layoffs during this temporary COVID period. Now, some people are still saying that you still can't do it, you still can't lay people off, and other people are saying, well, no, you can. And in fact, we're involved in a case in this right now, and the case is going to the Court of Appeal. We don't know when, but we're expecting some guidance from the Court of Appeal in the next months as to whether or not that's indeed the case.
So the last question is, what should an employer be asking for proof of vaccination?
Well, I think what you'd be asking for is to have a look at the vaccination receipt that the paper receipt that we've received when we got our vaccination, and later on when they come out with their app, the app and the QR codes, to have a look at that. The only other thing is whether you decide to retain a copy of it. Retaining a copy of it proves that you've done it, you've done your job, but then puts you in charge of some confidential information that you've got to take precautions for privacy considerations. So you've got that risk of now having possession of confidential information versus the risk of saying, yes, I did it, I checked off that I looked at it, but I didn't keep a copy of it.
Great. Excellent. Ian, thank you so much for the in-depth answers you gave to the questions raised. And Stephanie, thank you for your very informative presentation. Unfortunately, this is all the time we have, and it's the type of topic that can be discussed for hours on end. Should you have any more questions, please feel free to contact Mason Bennett Johncox. Their information is on the screen below. I'm Jonathan van Bilsen, and on behalf of the Chamber of Commerce, I'd like to thank you very much for joining us today. Stay safe.